Okay, welcome to the Judicial Proceedings Committee voting session. We have, I guess, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 bills on the voting list. We're just going to go in sequential order from the top of the list. So we'll start off with Senate Bill 498, which is a withdrawal, but we still have to vote on it. Is everyone okay with that? It's a duplicate bill from one that she had pre-filed, I think. So it's just a duplication. She wants to withdraw this one. Is everyone okay with that? All right, great. Okay, so Josh, you're up first. Senate Bill 32.
So this departmental bill limits the liability of the Maryland Transit Administration in a tort action to $800,000 for a single claimant for injuries arising from a single incident or occurrence. The bill applies prospectively and may not be applied or interpreted to have any effect or application on a cause of action arising before the bill's effective date. So currently there is no cap on liability for the MTA.
Oh, see, there was some compelling testimony that I think missed the deadline from MHA, but if you open the bill file, you'll have it. But open for discussion.
So here's my quick thought. I generally like to support these, and I generally don't like. I'm not sure if there's other bills this year to increase the cap on suits you can bring the government. I don't hardly ever vote to increase the cap. But the one thing about this that gives me heartburn is the reason they were not included is because many of these services had been private sector services. And it bothers me that we would, if government is running this service, and in this case, and I understand for the argument, I'm in favor of local tort claims because there's many times where government's running things the private sector can and so forth. But in this one, you had the private sector running it. They, of course, have one standard of liability, which is what we set. And then the government can come in and run the same service and have this other set of a capped liability. So there does seem to be, and I remember this issue in the House, and actually I've had opposed it in the past because of it seems to give an unfair competitive advantage to the government if the government's going to run the same service as the private sector, in that they'll have a lower liability to run these trains and buses and everything else, things that the private sector many times is running and competing with the government to provide these services.
Senator Castley.
Argument can be made about literally everything that we provide caps for, because you can always the government can privatize everything we do, and so this is the same as really all the other matters that we provide caps for. It's the fact that government ultimately ends up undertaking an effort usually quite frequently reflects the fact that it's just not profit making for the private sector, but the public still demands a service. I think these transportation services are very difficult to subsidize privately. You just watch all the grief that the administration got just trying to reorganize bus lines over the last few years. They tried to do that based upon totally practical measures, but the public was like, no way, we don't want practical, we want convenience. And that's what the public demands, is the convenience that only the government can possibly provide. So I think that it's important that we get behind this. This is a government expense, and ultimately the money is paid by the taxpayers. That's who paid. When you see $800,000, that's us. That's our tax dollars. And at some point, liability becomes so high that even the government can't afford to do it. And when we don't do it, it just doesn't get done. Your transportation is just eliminated, and nobody benefits in the long run. So I think it's an important provision, and we ought to stand behind it. Thank you.
Is in this case, I think they are an active competition. So, for example, the MARC, which comes from Brunswick, CSX runs that. A private company, typically will run these, and they're back and forth. Some years Amtrak will run it, some years the state. And I'd actually like to see more private companies running these. I think that actually ultimately saves the taxpayer money. But in this case, we're giving an unfair advantage to the government to run it, and this is why they have been excluded. because they're going and taking over things that the private sector was running. And so that's why we have excluded them from this in the past. And so that's my problem with it.
Further discussion? All right, so I think Senator Huff had a motion.
I mean, it's unfavorable
Okay.
for me.
Is there a second?
Second.
All right, we'll roll it that way. We'll see what happens.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Casserly.
I stand firm against the MHA. No.
Senator Heddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. Next up, we have Senate Bill 43. Jamie.
So Senate Bill 43, just a recap from last week. This bill expands the list of individuals that a law enforcement officer is statutorily prohibited from engaging in sexual contact, vaginal intercourse, or sexual act with to include a victim, witness, or suspect in an investigation during the course of an investigation that the law enforcement officer is conducting, supervising, or assisting with, and also prohibits that conduct with a person requesting assistance or responding to the law enforcement officer in the course of the law enforcement officer's official duties. There is an amendment that was sent out to your offices, and the amendment is based on language that was both suggested by advocates as well as some of the points raised at the last voting session. It provides that a law enforcement officer may not engage in sexual contact, intercourse, or a sexual act with a person who is a victim, witness, or suspect in an open investigation that the law enforcement officer is conducting, supervising, or assisting with if the officer knew or should have known that the person was a victim, witness, or suspect in the investigation. There's an exception under the bill as it was drafted. The amendment actually alters that exception to the prohibition and states that it doesn't apply if, one, the officer had a prior existing sexual relationship with the person, two, an interim, temporary, or final protective order between the parties is not in effect at the time of the sexual contact, intercourse, or sexual act, and the prior existing sexual relationship was voluntary. It strikes a word in the bill as drafted, provided that the prior existing sexual relationship had to be legal. It seemed that there were some concerns about that in the last voting session, but so that's what we've got for the amendment.
Senator Carter and then Senator Casserly.
Thank you, Mr. Chair. So in taking a look at the bill, even before the amendment that you just read, Jamie, I fully support the bill. I simply think that the language, even in the bill and the amendment, some of it is not necessary. I personally just don't think it's necessary to state emphatically that something that's already not legal is illegal. So I think, in my opinion, it is sufficient to simply say, unless there's a prior existing relationship, and we then can presume that illegal sexual relationships, such as those that are prohibited by a protective order and other things, are not going to be accepted. And then I think too, because I think when you start naming like all of the iterations that could occur to make that relationship unacceptable or illegal. I mean, I just think, you've actually left out, just because like the victim or witness doesn't want to. And that's a big issue too. So I don't think that we need to be that specific. I think it's actually fine without all of that language, but that's just my opinion.
So I think we should respond to that, but Senator Castley, go ahead.
Yeah, I think I absolutely agree. I think my comments are the same as Senator Carter's. Basically, if it has a prior existing relationship, boom, done. If it was coerced or anything else, well, there's a crime there. So I don't think that's not going to be your defense. I was raping her before this. So it doesn't sound like a very viable defense. So I think that I totally agree. I would just request that maybe we can have council. We could take a vote in principle and have council adopt an amendment consistent with what Senator Carter is proposing, because I do agree with everything she said, that the bill is an appropriate bill, that the limitations are appropriate, but we just need to simplify this. I'll just note that in the amendment that's proposed, it falls victim to Senator Carter's concerns, because, for example, it concludes with the prior existing relationship was voluntary and free from coercion. Well, of course it was. We were not going to assert a defense with a forced, we had a forced sexual relationship, isn't going to fly as a defense anywhere. So, thank you.
So I'll ask the open question, like for I just asked this council, but like for what if it's voluntary but not legal? Like you have a prostitute, you exchange of money or something like that. There's prostitution. I mean,
does that really negate this thing? This is talking about people having. I mean, this is about whether it's a defense, sex with witnesses and stuff. If you knew the prostitute was a witness, then the defense doesn't stand. But just because the officer had sex with a prostitute, he's guilty of prostitution. We're not taking it out of that. He's probably be fired because he did that. But it wouldn't negate that he was not intending to have sex with somebody who was a witness in another thing that he didn't know about, right? That was not something that was there. So I'm not sure why that makes a difference. Maybe I'm wrong.
the amendment in concept then, because we could adopt that in concept, but you're saying strike what?
Everything after person, I think it was. I don't have the bill in front of me, but I looked at it earlier. I thought that was the prior existing relationship. I mean, if you want to say prior existing legal relationship, I don't have a problem with that, but I don't think you need to add, that's not subject to a protective order, a peace order, a divorce decree, a stay away. I mean, it's too much. It's not necessary, because if it's already a violation of the law, you don't have to restate it under this.
No, isn't it belts and suspenders? I mean, a bit, just to be really clear.
You run into problems because now is excluded. If you're general can include a whole lot, but once you've given specifics, then if you want, you could have exhausted the laundry list.
You probably remember, that basically if it's presumed that if it's not included here, it was intentionally not included. So if it's not included, then it doesn't count, whatever that term is. What is it called? It's Latin. Yeah.
Something like, it's in a Latin term, yeah.
But it's not reported, then let's say you have a prior sexual relationship, like you said, like you raped someone before, it was never, the victim never reports it, never does anything, and then you come back and then you're like, well, I had a prior sexual relationship with this person, the other person says, hey, well, that was actually rape.
I'm sorry, but I don't think you classify.
No,
It's a
no, no,
sexual
no, no, okay.
relationship. I mean, the term relationship implies some degree of consent there. We had a sexual relationship.
Something free
No,
of
you raped her.
coercion, or, okay, I got it. Sexual contact, I guess.
Incestuous or predatory.
Fair enough. Senator West.
Expressio unius est exclusio alterius.
I don't think it's confusing as to what the advocates are trying to do here. They were specific to the prostitute police officer relationship. That's what they're trying to exclude from counting as a prior existing relationship. And so we're kind of tying ourselves in knots over one specific example, but I do think that example happens in real life. And I do think if we want to capture it, if this is not the way to capture it, we should think of some way to capture it. Because I think that's the example that they're trying to make clear is excluded from a prior existing relationship. And we can't seem to find the words to describe it, and maybe we just want to be very open about it.
Well, then what's wrong with just saying prior existing legal relationship?
That's how the bill came in as drafted, but others had problems with it.
My problem is with adding those specifics that are already against the law, because they're not all inclusive of all of the reasons.
I mean,
and two,
I supported Jill's amendment where she included legal, and I conceded and just deleted relationship period, and then strike the next 3 lines. I'm fine. So it would be with a prior existing legal relationship period.
So I guess the new language and concept would be, well, I'll read it from the language. Paragraph 1I and 2I of this subsection does not apply if the law enforcement officer had a prior existing legal sexual relationship with the person, and then strike everything else in the exception after that.
Include the knows or should have known language because that was in the on page.
Well, I'm just curious why we wouldn't just include the protection order piece in.
because it's covered. Violation of those orders that are in place is already against the law. There's no reason to restate that you're not allowed to do something that is already against the law. And I think it's covered with legal. I just think that you go down, you open up kind of a Pandora's box, and if you aren't fully sure that you're including everything that you don't want in there, then the things that are not included run the risk of, there being an assumption that they were intentionally not included, which is the Latin term that I was trying to think of that Senator West looked up and found it. So all I'm saying is it's overkill. You're doing too much. We're making the point. We're making the bill with that. Keep it simple. It makes more. It's better written, better drafted. Makes no sense to add all that other stuff.
Right. So that if there is an existing interim order that says you can't do this and you're doing it, it was not a legal relationship. That's the point. We're done. If we put legal, we've covered all that.
Senator Carter, you're right. So, look, Jamie, can you just go over then incorporate every aspect of the amendment apart from, and then just stop at the word, so we get existing legal sexual relationship with the person, everything else is struck, and everything above that is incorporated in this amendment, okay?
So, right, I guess the amendment then would be redrafted to say everything in the prohibition that had been changed in the amendment would still be there. But the only thing that would be changed would be the exception in paragraph 2. And as the chairman indicated, so it would be paragraph 1 Roman I and Roman II I of this subsection does not apply if the law enforcement officer had a prior existing legal sexual relationship with the person, and then that's the extent of the exception.
Does everyone understand that? Senator Sidnor, good. What do you think of it?
Just one question.
Senator Cassidy.
Yeah, so when you were just reading, Jamie, are you reading off this amendment here, or are you reading off the bill?
Should have received a reprint that was emailed to your offices for the voting packet.
But that includes the notice of known language and that. Okay, thank you.
It does.
I have no questions. I'm fine. Thank you.
I did just one technical thing to point out. In the bill on page 3 and line 1, we did strike during the course of an investigation. It seemed like redundant language from the lead-in that at the bottom of page 2. So the way that the bill originally read was a person who is a victim, witness, or suspect in an open investigation during the course of an investigation that the law enforcement officer is conducting. So that during the course of an investigation language just seemed a little redundant. So that was stricken.
Okay.
That was the Bailey amendment.
And then, right, it was clarified that it had to be an open investigation.
Senator Sinai.
So just to be clear, Roman 2 and Roman 3 would go away with this particular change, correct?
Yeah, that's correct, Senator. So everything, it looks like line 10 would just be the end of the exception with relationship with the person, and then that would be it.
Any other further commentary on readiness, questions, comments, concerns? All right, can we adopt the amendment? Is everyone okay adopting the amendment? Okay. Okay. All right, so then the motion is for favorable with amendment.
Second.
Vice Chair Waldstreicher,
Yes.
Senator Lee,
Yes.
Senator Cassidy,
Yes.
Senator Heddleman,
Yes.
Senator West,
Yes.
Senator Sidnor,
Yes.
Senator Jackson,
Yes.
Senator Bailey,
Yes.
Senator Carter,
Yes.
Senator Huff,
Yes.
Chairman Smith.
Yes. Okay, next we have Senate Bill 44. I'm gonna hold it, working on some amendments, but that's held for now. Senate 44. Anyone have any concerns, questions about that?
No, I mean, I submitted my amendment.
Okay, got it. So I'm gonna work on some stuff and then we'll discuss it at the same time. Okay, great. Now we're on Senate Bill 122, and that is Jamie.
So Senate Bill 122 generally prohibits a person from leaving a dog outside or unattended for longer than 30 minutes without access to continuous, suitable shelter during extreme weather conditions. There are exceptions to the prohibition for hunting, livestock herding, sledding, sporting as defined under the bill, or training. Violators are guilty of a civil offense, punishable by a warning for a first violation, a civil penalty of up to $500 for a second violation, and a civil penalty of up to $1,000 for a third or subsequent violation. In the bill, extreme weather conditions are defined as temperatures that are below 32 degrees or above 90 degrees. Situations where a active weather warning has been issued by the National Weather Service would also constitute extreme weather conditions. And in order to qualify as suitable shelter, the shelter needs to be ventilated, have a solid floor that's raised off the ground, have a weatherproof roof, have 4 walls, one of which is a doorway, It also needs to have insulation to allow the dog to maintain its normal body temperature and be suitable for the species, age, condition, size, and type of the dog.
I don't know. I want to speak on it whenever we're ready. Are there amendments? Oh no, it's amendments on I have on the animal control bill. I mean, we've had this bill many times in the past. I still don't understand it because it to me it weakens the current law. Right now, the current law is if you keep a dog in unsafe or unsanitary conditions. So they have wide latitude to go in and use common sense and decide when to punish or warn an owner, punish an owner, whatever. But once you start to set temperature guidelines, 89 degrees. What is 89 degrees and 100% humidity? You kept the dog out all day and the dog's, like dying out there. Versus right now, they have wide latitude to decide and use common sense. And plus, there's other dogs, like what if you have a husky? Huskies love to be outside. They're bred to be outside for like hours in the cold. Even mine, we've had beagles for years and years. And beagles love, when it gets cold, to put their nose down and go around and smell and things like that. But it doesn't make sense, for one, this actually weakens the law. And two, they said it makes it more simple for people to understand. No, it doesn't, because this is only a floor, and they admit it. They're going to go around and set different standards all throughout the state. So it doesn't add any simplicity to the law. Right now, we give them completely wide latitude, and if we pass it with these strict requirements that they set up, then it actually weakens the law.
Yeah, look, this is a snob bill, because this is, if you're pulling down good money and you got to go buy a doghouse just because the law says buy a doghouse, I guess it doesn't really matter to you. But if you're like so many people in this state who money does matter, and you let your dog sleep under the tree in the back, or you have an umbrella or a shade, that's not good enough. I got to buy a doghouse just to say I have a doghouse. And, well, it's 90 degrees. Well, it's always 90 degrees in Maryland in June, July, and August. So you're gonna, anytime your dog's outside for 30 minutes, you're gonna have to have a doghouse. It's just, it just makes no sense. So the bill is inflexible. Had this thing been a bit more flexible, I mean, I like dogs. I don't want dogs to be outside unnecessarily. We didn't really get we didn't get any testimony that said that counties are having difficulty looking out for animals and imposing fines or whatever for dogs that are abused. And we've always stood behind in this committee, filling in holes, obvious holes in the bills, the laws that dealt with animal cruelty. We made a number of amendments, but just say everybody's got to buy a doghouse in Maryland just isn't good policy. Thank you.
You got to put insulation in there too.
Thank you, Mr. Chairman. I agree with Bob on this. I drafted some proposed language on page 3 in C, which would divide the well, I'll just read it. Except as provided in subsection D, this section, a person may not leave a dog outside and unattended for longer than 30 minutes, A, without access to continuous suitable shelter during extreme winter weather conditions, or B, without access to shade or continuous suitable shelter during extreme summer weather conditions. Shade, every dog I've seen would much prefer to lie under a tree or a bush than in a hot doghouse. So.
Getting back to the point of the bill, the current law is you cannot keep a dog in unsafe or unsanitary conditions. It covers all this. It's completely covered. So to get into a bill that gives completely broad latitude, I'd almost be in favor of this bill if people were coming in and saying, I'm being harassed by animal control because I got a husky and they're coming in and they're charged with this, that. And I said, okay, well, then we need to define it back because the state is overreaching. We need to bring it back. We've given the animal control broad latitude, and for some reason they are confused and think that a bill that lessens their ability to regulate is helping them. And I don't understand why. It's as if they've never read the current law. It's right in the fiscal note. Unsafe or unsanitary conditions. Everything this bill's doing, they can already charge. If anything, this bill restricts when they can charge. This makes it worse for dogs and the people they're trying to help.
Yeah, all right, like, just for, I've sent in some unreadiness on this, but still, I mean, like, we were talking to Jamie, and you pulled the section of the code. If a person has charge or custody of the animal, and this is from the fiscal note as well, as an odor or otherwise unnecessary, they fail to provide the animal with nutritious food in sufficient quantity, necessary veterinary care, proper drink, proper air, proper space, proper shelter, or proper protection from weather. The penalty is up to 90 days and almost $1,000 per infraction. Senator Bailey.
So I'd have to say that I do agree with my colleagues on this that have been speaking about this and the unsafe. And I'm just going to say, coming from a rural area, and I don't know how many of you spend as much time outside as I have, but I have hunting dogs. And the fact is, if I was not able to let them be outside for some time when I monitor them without being inside, and we go to go retrieving, right, in the water when they're actually engaged, those dogs would freeze to death, right? They have to have time to build their coats. That is not a situation that is unsafe for them. It is the fall, and that's the way. It's just like us putting on a coat. What we have in existence really does work, and it doesn't affect the farmers. It doesn't affect people that need dogs that are outside all the time. If they have a barn, something they can get into, a health officer goes and he sees that that is fine for that animal. It doesn't. Every suitable place doesn't need a floor. For all those reasons, I would move unfavorable on this bill.
Mr. Chairman, I'd like to make a motion to hold the bill.
All right, bill is on ice. Okay, Senate Bill 143. This is the one you had amendments on, right? Senator Huff, you had amendments on this one?
Yeah.
Okay, well, let's let Jamie run us through where we are, and then if you want to explain your amendments.
So Senate Bill 143, as drafted, increases the amount of marijuana for which a person is guilty of a civil violation and subject to a citation from less than 10 grams to less than 1 ounce. It also establishes a rebuttable presumption that a person in possession of less than 1 ounce of marijuana is not in violation of the prohibitions on distribution of a controlled dangerous substance, or 2, possession with intent to distribute in the absence of any other evidence of a violation of those prohibitions. There are 3 amendments from Senator Huff. You should have been emailed those this afternoon. The first amendment that I'm going to go off of has the number 253321. So that's Amendment 253321. And it provides that a driver or a passenger may not smoke or otherwise consume marijuana in a passenger area of a motor vehicle on a highway. Under Section 27101 of the Transportation Article, this would be a $500 misdemeanor. It puts this provision in the section of the code that prohibits alcohol consumption by a driver of a motor vehicle in a passenger compartment. The next amendment, or I can pause if you'd like to go through each one.
No, just mention them all and then
Okay.
one by one. Which can you for the guy then?
Sure. The next amendment is 943-321.
We're withdrawing. I don't want to offer that one. I want to offer the 823823.
Okay. So the last amendment is 823823, and that provides that notwithstanding any other provision of law, the governing body of a county, city, or other jurisdiction may enact an ordinance regarding the smoking of marijuana in a public place. Under the amendment, public place would mean a place to which the public or a portion of the public has access and a right to resort for business, dwelling, entertainment, or other lawful purpose. Current code specifies some specific examples of what a public place is. And, there's, in your materials, there's also a copy of Senate Bill 127 of 2018, as amended by the Senate, and that also provided a provision prohibiting a driver and passenger from smoking or otherwise consuming marijuana in the passenger area of a motor vehicle.
Senator Carter.
Thank you. I'd like to speak briefly to the amendments. I don't have any, I actually agree with the second amendment regarding the flexibility of a local jurisdiction to enact an ordinance that pertains to their public areas. But I don't, I'm concerned about the first one because, and you can answer this, when we passed the civil citation or decrim for the 10 grams, we did not include that provision about passengers not smoking, correct? We did not. And then when we passed the medical marijuana, we didn't put in any qualifications about a passenger not being able to smoke in a vehicle. So I have some real trepidation about, as we expand the amount, I don't see the correlation between expanding the amount for which we will not criminalize and prohibiting a passenger from smoking. A great deal of the discussion that we had in determining to pass the 10 grams was about ending racial disparity, but also ending for everybody, people having to be hauled into jail. I feel that if we add this no passenger smoking, I mean, it could be a passenger that's not driving that has a medical marijuana allowance or whatever you call it. They're supposed to be certification. But to me, that just it kind of refutes any intention that we have that we would work toward stopping the racial profiling and the stops and searches in vehicles, especially for young people and black people in vehicles. And so, for those reasons, I would like to pass the bill without that qualification of that First Amendment.
So I can just speak on the amendment.
Yes, I want to get Senator Jackson.
Yeah, sure. Just real quick. I think the first one with parks, I just want to get at, I don't want to have this hypocrisy where we are banning people from smoking cigarettes and then allowing people to smoke a bunch of marijuana in parks. That's sort of self-explanatory. This amendment that I offered is the same one that we've passed this bill. I want to say we did it this term with this amendment on there. We did 1 ounce. Sorry, we all set up. So the beginning of this term, the first year, we did it with this. We went to 1 ounce, and then we dealt with the driving issue. I think it was a great compromise. This was a big issue from the state's attorneys and both sides. We did it together. We compromised it. We've passed it at least twice, if not 3 times, going to 1 ounce and adding this amendment. And we did that. It was actually, I think it was unanimous every time we did it through the committee. I just think that that's sort of a common sense view that people should not be smoking marijuana in a car. That's not safe. You can, from marijuana, you can get a contact high if you're driving around in a car and somebody's smoking a joint the whole time. But also what's happening is you just pass it over to the guy in the passenger seat, and now all of a sudden you're getting out of it, and that's what we're trying to get. I just think that's a view that people should not be consuming marijuana and driving around. I would hope that we could continue to pass that amendment with this legislation. So it's got a history passing with it.
Thank you, Mr. Chairman. I guess my concern is the maker of the amendment spoke to the passage in of the increase from 10 grams to 1 ounce. An ounce is a lot. I mean, we're talking about you go from 10 grams to 1 ounce, and you want to dispel the notion that there is a distribution component to that. That's a lot. I mean, how much do you really need for an individual? So I guess my concern rests with the amount.
No, I got it. I mean, I think, like, this is brought to my attention just because I'm not a consumer, but, like, you know, just as you would have, and this is the analogy that was given to me, is just that you'd have, you know, maybe a couple of things of bourbon, some different types of vodka, like whatever. This is kind of like a product that people have, you know, as if you're a medical marijuana patient, you may have multiple different strains and multiple different volumes. So I don't know. It just maybe excuse himself. When my first year when we were here, I was looking at the voting record. But so just to be clear, Senator Huff, like, your amendments are no smoking in public places, and the second one is just you can't smoke or ingest in the car where you could otherwise get the other person high while you're in the car. Or otherwise ingest marijuana. I mean, and we move to the ounce. That's your amendment. Those are your two amendments. I mean, that's.
I mean, essentially, it's the same thing that we passed as a committee in the past. The only thing I wanted to add was the park thing, because I was just thinking about it, and I thought that made sense.
So, how will this affect in the law, which is the lack of criminalization of 10 grams? So now, that isn't in place for 10 grams, but as we move up the amount, then suddenly we're going to restrict or place greater restrictions on what's already in the law?
But isn't it good policy not to be smoking in public? And isn't it also good policy to not be high in the car?
I already said that I agreed with the amendment about the jurisdictions in the public places, but I believe that you just set up the pretext for pulling over people, and honestly, a big part of the discussion in moving this direction is to stop that. And so, no, I don't necessarily think, to be honest with you, I don't necessarily think that a passenger that has marijuana in the car is necessarily a detriment to the driver. Like, I don't really know. I don't believe it. It depends on you know, the potency, I suppose. But we're talking about drivers. First of all, I don't agree even with the Senator Huff scenario, because let's be clear. If a police officer comes up and the driver is smoking and he just hands it to the passenger, it doesn't matter. The officer is still going to order them all out of the car and most likely search them. So that you're not. I mean, that little thing isn't going to change anything. If the officer smells marijuana, the officer will use it as a reason to pull over, to stop, to search, to look for other stuff. They can do that now, even with the 10 grams. But I thought that by going up to the ounce, we were trying to say as a matter of policy, we don't want you officers pulling people over just because you suspect marijuana. But in adding this, you're kind of like refuting the whole purpose, in my opinion. So I just don't think we need that amendment. But, I mean, have you looked, and did you say that, like, other states do it?
I mean, no state should want people to drive around smoking marijuana.
You can't be messing with the passenger. I mean, what else can the passenger not do? Next will be like the passenger can't be drunk.
Marijuana more favorably than we do alcohol. So, you know, Bud Light is treated more harshly than Bud Light. I mean, it's ridiculous that we would allow any marijuana, particularly if it's burning in the car, or on. This is just ludicrous not to treat marijuana in automobiles differently. We sit here day after day listening to testimony about people being killed and maimed in automobile accidents. There's no way you can suggest that that's not just as intoxicating as light beer to have marijuana, and not to treat it severely and discourage people from using marijuana in their cars is just totally irresponsible as this General Assembly not to do that. You can sit at your home and use marijuana. You can sit in the backyard and use marijuana. You can sit on the front stoop and use marijuana. The most that'll happen is a cop might take your marijuana away from you. You're not going to lose it. So by the whole idea that we got to go out in the car and hide and smoke marijuana or ingest it, it's just, there's no reason to support that. Thank you.
I think this has been a really good discussion. I think it's kind of the best of JPR. So, Mr. Chairman, I would make a motion just to hold the bill for now. I think that there's been a lot of turnover among the advocates that are supporting this legislation. They weren't necessarily party to the previous compromise on this bill. They want to take time to look at the amendments. I think we should give them that time. So I would make a motion to hold the bill.
Second, I think that's respectful. It's been seconded. Yeah, I think it's right. I mean, they're obviously, look, Senator Carter, I'll let you go ahead and speak on it, but I mean,
I just had one more thing.
we're still working on it. Yeah.
Is that we already have something that discourages people from doing that. It's called driving under the influence, which covers both alcohol and drugs. So, you know, somebody that gets caught that's driving high, they're still going to get pulled over, and they're still going to most likely come into a bad encounter with law enforcement. So I'm not concerned about that. That's all I have to say.
I listened to those arguments before, and I was really curious. So I actually went to the Maryland Drug Lab to say, I watched them. I went actually to the lab over in Pikeville, whatever it is. Our ability to prosecute people for driving while high on pot is so poor. I mean, alcohol is so easy. You do the blood, you do the, boom, you're done. Marijuana, we lack the capability to do that in any realistic fashion. So the only thing we can do, the only meaningful effort we have is to say, you can't have it in there. You cannot have an open container. The guy in the back seat in Maryland can't have an open container of Budweiser in the car. So, and we're saying, well, but we should treat marijuana, you know, no sense in ruining the party. Yeah, then we should ruin the party. People are dying on the highway. Ruin the party. Take your party home, take it to the backwoods, take it to the streets, take it out of the car. Thank you.
Detect whether somebody's driving under the influence, under pills or some other type of drug, but yet they are, and yet they get prosecuted for these things all the time. So clearly, it isn't impossible. Most likely, the officer is going to suspect that the person is under the influence, and then he'll do whatever other kinds of whatever he has to do to confirm or dispel it, and then if it rises to the level that he probably has probable cause, he'll make an arrest. So it's not impossible. And they do it all.
No, I think, got it. Senator Bailey, you want to get in?
So I was going to say, I mean, when we enter the world, when we're talking about DREs, drug recognition experts, it is not impossible, Senator, but it is very improbable. It makes it very difficult when you're dealing with somebody under the influence to have everyone trained when you're talking about controlled dangerous substance rather than alcohol. Alcohol, we've dealt with it through the General Assembly. Everything is laid out. It's very easy to follow the rules. It's different with drugs, and I appreciate the fact that we hold this so we can look at this more in depth.
Got it. Looks like it's going to be held. But I mean, I think we all can appreciate the kind of over-incarceration of black and brown populations and don't want to create another instance for a pretext, but at the same time, there is an underlying public safety issue here that we have a responsibility to uphold. So, okay, held. Good discussion. All right, where are we next? We've got a pile of paper. 159. Oh, here we go. 159, yes.
So Senate Bill 159 requires new animal control officers to complete at least 80 hours of training on animal care within the first 12 months of employment. It also requires at least 6 hours of continuing education on animal care every year thereafter. The training must be approved by the appropriate unit of county or municipal government. During the two things to note, during the bill hearing, there was a question about whether this was appropriately placed in the criminal law article. As a technical matter, it could be relocated, the provisions could be relocated to the local government article under Title 13, which already contains provisions on animal control. There is an amendment from Senator Huff. It is Amendment 433622. It's Amendment 433622. It establishes a list of topics that must be covered in the training required under the bill. The training would need to include animal cruelty investigations, association between animal abuse and abuse of the elderly or domestic violence, use of legal resources, including constitutional law, the Maryland Code and county codes, lawful searches and seizures, professionalism and ethical standards, evidence collection and the chain of custody, preparation for civil and criminal proceedings, including basic trial principles and due process protections, conflict resolution and officer safety, including physical and mental health, and animal diseases and zoonosis. The amendment would also authorize the governing body of a county or municipal corporation to require other training in addition to the training specified in the bill, and finally provides that the continuing education must include instruction on current laws applicable to officers.
So the bill came in pretty basic, just a requirement, but when I was questioning in the hearing, the Montgomery County office about it, he was listing all these things that they should be required, and I thought if we're actually going to require it, we should actually require that they know the law, and I actually just got the language from Montgomery County of what they require. I thought it was excellent, and he circulated it with the other offices and all the other folks, and they signed off, so I just think it makes the bill a little fuller and better.
Mr. Chairman, these amendments are considered friendly to the bill. I would move the amendments.
Great. Yeah, can you explain those? Yeah.
Sure.
Sorry, say that.
Sure. Just to reiterate on the point that was raised during the bill hearing, so looking into it, we could take it out of the criminal law article and put it into Title 13 of the local government article.
I would make a favorable on that.
All right, it's been seconded. Everyone's okay? Great. All right, is there, Senator West has a question.
Could join as co-sponsors.
You want to be, does a JPR pile on, or everyone wants to be on? Does everyone?
I'd be happy to be listed.
All right, looks like, is everyone, all right, everyone's on it. Everyone's on it. Can we make it the third amendment? Everyone's on as a sponsor. All right, so with that, can you do that you can do that?
Oh, yeah.
Okay. All right, so with that, bills for you, 3 total amendments. Is there a motion?
Motion for favorable.
Seconded. So the bill seconded before you as amended with amendments. We can do a roll call. All right, everyone's fine. Everyone's okay with this, right? Good. All right, great. All right, so we're holding 264. That leaves Senate Bill 220. There are a couple technical things that I wanted to work out with the sponsor. So do you want to hold it or do you want to discuss it? How do you?
Truthfully, I'd rather discuss it if we could, because I think I have some responses to some of the
Okay,
technical
great.
issues.
Great. All right, so I think, Jamie, you're the counsel on that.
So Senate Bill 220 alters the list of protected classes under the existing hate crime statute to include gender-related identity or expression, as well as age. As drafted, the bill also authorizes a sentencing court to order a person convicted of a hate crime to complete an anti-bias education program. It also requires the Board of Regents of the University System of Maryland to develop an anti-bias education program and provide informational material concerning the program to the Maryland Commission on Civil Rights. The Maryland Commission on Civil Rights is required under the bill to work with the Administrative Office of the Courts to ensure that persons required to complete the anti-bias education program receive the appropriate informational material. Senator Hettleman has provided an amendment. It is Amendment 193-825. It's Amendment 193-825. It would strike provisions of the bill and requires the University System of Maryland to manage the development of an anti-bias education program. It also alters the definitions provided in the bill. It provides that the definition of gender identity has the meaning stated in Section 20-101 of the state government article. That provision provides that gender identity means the gender-related identity, appearance, expression, or behavior of a person, regardless of the person's assigned sex at birth, which may be demonstrated by 1, consistent and uniform assertion of the person's gender identity, or 2, any other evidence that gender identity is sincerely held as part of the person's core identity. There could be a technical issue with that definition. The amendment defines gender identity, but the bill uses the term gender-related identity or expression as the basis that would constitute a hate crime. So the definition doesn't actually match up with or the defined term doesn't match up with the term that's used in the text of the bill. Additionally, what the amendment does is it strikes the provision adding age to the list of bases for which a crime may become a hate crime under the statute. And finally, it provides that if a court requires, so in the situation that a court requires a defendant who's convicted of a hate crime to complete anti-bias education, the court is required to work with the University System of Maryland to ensure that the defendant is provided with the materials that were developed by the university system under the bill.
I see what you're saying about the gender identity and gender-related identity expression, and if we should be consistent and just use gender identity, that's fine.
Senator Hillman, do you remember the discussion on this point with the difference between expression and identity? Do you remember, because I asked the question and I forgot the answer. Do you remember that back and forth? Why they wanted to parse that out?
I don't remember the specifics of it. But I did run it by the advocates. So,
got it. Okay.
Yeah, that was their way of dealing with this.
Okay.
Yeah. I stepped out earlier to do that.
I think that what we've grappled with before is just like I know Senator Cass, I got to send you that implicit bias stuff from Dr. Ray at Maryland, just as a sidebar. But, because I don't think it's sent through the chat when I send that to you. I got to send it to you. Don't worry about it. I didn't send it yet. The difficulties with having, I guess, with the University of Maryland to develop, or the university system, develop this course, and then have them be basically the only vendor from which you get that, that product from.
We had a conversation with them.
Yeah.
They're Office of Diversity, Equity, Inclusion, and they were talking about pulling in people from different places and developing it with consultation from experts. So
that's great.
This was something they were supportive of and willing to do.
Okay, then the second piece, I guess, is making the courts have to do this. They have to, under the language, the court has to give them this training, this particular training.
Right. The issue was that there weren't already existing there weren't a ton of pre-packaged things already out there to use. I mean, I'm willing, if the court wants flexibility on, finding their own system, and that's the will of the committee, I think we're willing to do that.
We wouldn't want to establish a state monopoly on anything, so might screw up liability and immunities and shit, so you probably should make it.
So as a technical, potential technical issue, the university system is required under the amendment to manage the development of an anti-bias education program, but the requirement for what the court would need to order is, it says that the court would need to work with the university system to ensure that the defendant is provided with the materials developed. So there might be some incongruity there between the universities being required to develop a program, but it's less clear about what the defendant's actually being required to get from it. So it says materials, but it doesn't say that the defendant actually needs to participate in the program that's run by the university system or that's been developed by the university system.
So they would develop it, and then the court would ensure that the defendant would participate in it. But I want to reply to Senator Huff, because Senator Huff, this committee did pass this bill last year. We had, the way it was framed last year is we left it up to the court to kind of find programs that existed that addressed the particular hate crime that the person engaged in. So if it was something that was anti-LGBT, we were going to put them in the direction of trying to find a national program that existed that addressed that particular crime. So this way, we figured this would be kind of put less of an onus on the court to go out and find, what particular hate crime program was out there.
I think we should put some sort of a maximum limitation on the number of hours of instructional time that the person would be required to attend, and not leave it totally up to the discretion of the court.
What did you have in mind?
Well, we did 80 hours for the Humane Society people, for their instruction. What do we do up to 80 hours?
Fine. That's more than, I mean, I don't know that we need, I wasn't thinking, to be honest, I wasn't thinking anywhere near that. And I think that, if that makes you happy, I'm fine with that, but, I'd leave it to the judge's discretion.
I think it should be left to the judge's discretion. I don't think you need a
Senator Lee?
number.
Yeah, you got it. All right, Senator West.
Okay, so I was obviously not trying to slow this process down, because I think hate crimes are a big issue, and I think it's something that we need to address. But next Wednesday, I already have a bill scheduled in this committee that deals with hate crimes. And I think that it would be a meaningful discussion to discuss that bill and this one at the same time. That being said, if there's no objection, I would ask to hold this until then.
That's fine. We're still going to work on these amendments anyway, right, Senator Edelman? Or like, are you think we're close on this? Or what?
I think we're close.
Are we close on this? Okay. Could you? Got it. Senator Bailey, I don't remember the bill that's coming up, but I know does it deal training of, like, what does it deal with?
So it doesn't deal with training, but it deals with people that are targeted when they're working. If they are working and a crime is committed against them, it is actually, if they're working in uniform as a police officer and somebody targets them, that we could include them in the ranks of hate crime.
So these,
I would say, I feel like that's a really different kind of bill than this is. I understand you're trying to add that as a protected class, I assume. I haven't seen the bill, so I don't know.
Yes. So, but the fact is, if we're going to talk about training and we're going to talk about issues such as that we should include different groups in there, I think that it's a worthwhile decision to make sure we include all the groups that might be affected, rather than just try to add them in later.
Go ahead.
Sorry. Yeah, so Senator, actually, you know what? We had that discussion earlier, and I didn't realize that these do. I don't think one will conflict with the other, and I think we could definitely have a one informed discussion on your bill, fair discussion, and if if we move forward with hers tonight or whatever, we'll keep talking about these amendments, see if we can do this real quick. I don't think it's going to hurt. All right. Okay, so where are we now with the amendment then?
I mean, do you want me to draft it for the committee for? Okay. So I guess the correction, if everybody has the N-line version, would be to throughout the bill change the term gender-related identity or expression to gender identity to match with the definition. And then it would be to, I suppose, currently the bill says if a court requires a defendant to complete an anti-bias education program under this subsection, the court shall work with the University System of Maryland to ensure that the defendant is provided with the materials developed under 12-120 of the education article. I suppose it sounds like the idea is to, instead of say provided with the materials, to say that to ensure that the defendant completes the program developed and by the university under that section.
So what if they just a timing logistics thing? Like, let's say it's
Years to develop. How do you?
There's no.
2023, the University System of Maryland shall manage the development of it.
What if they're going to be? Yeah. Okay. How about this, Senator Hiddleman? Tomorrow, let's all three of us. We're going to find an hour to sit down and fix this for good, and it'll be when we come back to vote next Wednesday. It'll be 100% pro ready. Okay. Let's seriously sit down tomorrow and do this. I just don't want to do. I don't think we. There are a couple questions on the fly. I don't know. I don't feel like we can do it right now. On the fly like this. Okay. With that, thank you. Can I have this? All right, there's one last announcement. So obviously we're headed into police reform is tomorrow, right? Is that none of the police reform bills going to be heard tomorrow? We've heard a slew of them before. We actually heard them in the interim. So the next step, and your offices have all received an email for this, would be basically we're gonna work session this. So we're gonna do them on Friday, the 29th, after floor session, which will end before 2 o'clock. We're not going to be here late on Friday nights or anything. So your offices have received this. So from 2 to 4, January 29th. The next Friday, which is February 5th, from 2 to 4. And then that Monday, February 8th, from 3 to 5. It's just going to be a work session. We're going to pull, elements, all the bills that we've heard, and have a discussion. You'll get an agenda for each day. And we'll work through it just to kind of go through. Really, it's to speak to the points of contention where there are some disagreement between either the advocacy groups or members on the committee. Because I think, frankly, there are a lot of things that are pretty close from both sides. But there are a couple of big touch points, so we'll mainly highlight on those, so that when we get to the voting session, we would have had a more informed process background. So. Advocates and experts will be available, but will not participate actively. So if we have a question of, let's say, FOP the state FOP will be able to tap into that resource. If we have a question from the ACLU, we'll be able to tap onto that resource. But this is a discussion amongst the committee members. It's committee product. This is kind of in the vein of Mac Middleton, Senator Middleton. So I called him up, and I always admired the way he ran his committee and ran processes like this. So using the Mac Middleton model, that's how we'll work through this slew of bills in the next couple of days. I think it'll be good for all of us, and just a little bit of extra time outside of committee. So I appreciate your indulgence, and stay tuned for an agenda for each day. Oh, sweet. So how many bills did we vote out today? 2? 2. That's great. All right. Who wants to be the floor leader for
43.
Senate Bill 43, which is Senator Elfreth's, the prohibition of sexual activity of law enforcement officers?
Who wants to break the bad news to the cops?
All right, Charles Sidnor, Senator Sidnor. You said it, not me.
And then Law Strikers, Humane Society.
All right, so you got your Humane Society. Okay, cool. Great. Excellent. All right. Have a good night. See you all tomorrow.